Companies Act, Section 219, Power of Inspector to investigate the affairs of related companies and other entities. Section 219 of the Companies Act, 2013 grants inspectors the authority to conduct investigations into the affairs of other entities related to the company under investigation. This section is particularly important when the inspector, who has been appointed to investigate a company's affairs under Sections 210, 212, or 213, deems it necessary to expand the scope of the investigation to include other entities with which the company has significant connections or relationships. The section allows the inspector to probe the affairs of related companies, subsidiaries, holding companies, or even certain individuals associated with the company if the investigation into their affairs is deemed relevant to understanding the affairs of the company being investigated. 1. Expanded scope of investigation. Subsection 1 provides the circumstances under which an inspector, already appointed to investigate the affairs of a company, may extend the scope of the investigation to include other entities. If the inspector believes that investigating the affairs of any of the following entities is necessary for a comprehensive understanding of the company's affairs, the inspector may proceed with such investigations, but only after obtaining the prior approval of the central government. A. Subsidiary and holding companies. An inspector may investigate the affairs of any body corporate that is, or at any time has been, a subsidiary company or a holding company of the company under investigation, or a subsidiary of the holding company. This provision is crucial because a company's subsidiary or holding company might have business dealings or financial arrangements that could impact or be relevant to the company under investigation. Investigating related companies, such as subsidiaries or holding companies, helps uncover the broader business relationships and financial structures that could be influencing the affairs of the company. B. Bodies corporate managed by companies' executives. An inspector may also investigate the affairs of any other body corporate that is, or has been, managed by any individual who served as a managing director or manager of the company under investigation at any relevant time. This provision acknowledges that individuals holding key management positions in one company may be involved in the management of other entities. These connections may be important to understanding the broader corporate structure, governance, and financial dealings that could be linked to the company under investigation. The inspector may expand the investigation to understand how such dual roles or overlapping management structures might affect the affairs of the company under scrutiny. C. Nominee directors or entities acting on company's instructions. Another situation where an inspector may expand the investigation is when a body corporate's board of directors is composed of nominee directors of the company under investigation or is accustomed to acting in accordance with the directions or instructions of the company or any of its directors. The involvement of nominee directors or entities that are influenced by the company's directions can significantly impact the company's operations, decisions, and financial activities. This provision allows the inspector to look into entities that may be under the influence or control of the company's decision-makers, even if they are not formally part of the same corporate group, to better understand the company's business dealings. D. Managing directors, managers, and employees of the company. The inspector may also investigate the affairs of any person who is or has at any relevant time been a managing director, manager, or employee of the company under investigation. The involvement of company executives or employees in the management and operations of other entities could be critical to understanding the company's broader business dealings, especially if there are potential conflicts of interest or financial interdependencies that could influence the company's affairs. 2. Requirements for approval. Before proceeding with such extended investigations, the inspector must obtain prior approval from the central government. This ensures that the extension of the investigation is deemed necessary and relevant. The requirement for prior approval helps maintain the integrity of the investigation process, ensuring that it is conducted within the bounds of the law and that the inspector is not overstepping their mandate. The central government's role in providing this approval ensures oversight and control over the scope and depth of investigations into related entities or individuals. 3. Purpose of extended investigation. The extended investigation can only proceed to examine the affairs of the related entities, such as subsidiaries, holding companies, or other connected bodies corporate, if the inspector believes that the results of such investigations will be relevant to the investigation of the company for which they were initially appointed. This provision emphasizes the need for relevance in the investigation. The inspector cannot indiscriminately expand the scope of the investigation. The additional entities must have a direct or indirect impact on the company under investigation, ensuring that the investigation remains focused and purposeful. 4. Report on the affairs of related entities. If the inspector proceeds with investigating the affairs of related companies, subsidiary companies, or other associated entities, they are required to report on their findings. The inspector's report will include the results of the investigation into these related entities, along with their relevance to the broader investigation of the company. The report provides the central government, the tribunal, and any other relevant authorities with a detailed understanding of how the related entities or individuals might be influencing or connected to the company under investigation. For more details, contact us.